All rise. We will obey. Please be seated. We will swear.
Thank you very much. Witness, welcome back to the court. Hope you had a good lunch. If you need more breaks, let me know. Okay?
All right. Thank you, Your Honour.
Mr. Steinberg, please continue.
Thank you, Your Honours. Perhaps before I begin, I can just give an indication of where I am. As I said this morning, I had hoped to finish this afternoon, but there have been some interruptions, and I note that we have an early finish. If I do run over, it will not be by more than an hour tomorrow morning, but I will do my best to wrap it up. Hopefully we will not have too many interruptions. Welcome
Those
back.
are not interruptions. They were proper, counsel entitled to make appropriate interjections. That's part of the process, Mr. Steinberg, you know that.
I did not mean in any way in a pejorative sense, Your Honours, but it simply does inevitably disrupt the flow and delay matters. But it is part of the process, of course. So before we broke for the luncheon adjournment, you'd been talking about the questioning of witnesses and the testing of the evidence of witnesses. You also told the chamber that you had access to the witness statements, both of witnesses who testified as well as those who had not testified. Is that correct?
Yes, that's right.
Apart from the actual statements of these witnesses, well, firstly, these statements, were they made under oath?
The statements, well, it depended. If they came before us or under oath, the statements were, from my recollection, the witnesses were reminded that they were to tell the truth. I don't think they'd be under oath necessarily.
And apart from these statements, did you have access to any other notes or assessments that investigators might have conducted regarding these witnesses?
From time to time, we spoke with Bob Grinstead, for example, and others. As you might imagine, in a commission of this type, those sorts of things, checks and balances, I'd call them, happen quite often during the process. So, but other than that, I'm just not quite following, actually.
As part of these checks and balances, what other records were kept in the process of investigators taking statements from witnesses?
Well, I mean, from time to time there may have been exhibits, for example, that they produced. There were other documents, government documents or information produced, for example.
I'm sorry, perhaps my question wasn't clear. I'm more interested in records or notes created by investigators in relation to the taking of witness statements, or the assessment of witnesses.
Oh, I'm sorry, I get you now. As a normal part of investigations, investigators do take notes. They write things like job sheets, for example, which from time to time flesh out just how they're conducting investigations, any aspects of their investigations that is worthy of writing down in a job sheet and that sort of documentation. That also I'd expect to be seeing summaries, for example, of their work from time to time.
And did you have access to those?
Well, yes, we did. We'd have access to all of the documents that either were created by the Commission,
right,
or referred to by the Commission.
Now, during the course of your hearings and deliberations, would you have taken into account matters relating to credibility or otherwise of witnesses whose evidence you'd heard?
Well, I see that as a normal part of the process, making an assessment of credibility of witnesses. I mean, that can be done from my own part from, I guess, a history of assessing the credibility of all sorts of people, witnesses, victims, perpetrators and others, actually. So that's from myself, that's a natural part of the exercise. But also, though, the credibility of witnesses appearing before us, for example, are tested, as I've said before, in a number of ways: cross-examination or examination by counsel and the commissioners themselves.
Moving on then to a different topic. Besides the testimony, in fact, you just mentioned that you receive various other exhibits and information through witnesses and otherwise. How is this material dealt with?
Well, in the beginning, of course, there was material already in the public domain, so the Commission and its staff used that as from an information perspective. You've got to start somewhere. And there were some documents already written by entities, for example, the United Nations entity on human rights had written something, a document about the violence, and others. And in addition to that, certain witnesses also provided their own reports. For example, the Kenyan National Commission of Human Rights, for example.
And that brings me then to the subject of the role of civil society in the proceedings. And I note that there is a heading on this in the introductory paragraph of your report at page 5. That's at ERN 0379. But it's probably not necessary to turn there. If you can tell the court from your recollection what was the role that civil society played in these proceedings?
Well, civil society provided an important role in work that they'd done, constituencies that they were representing throughout the post-election violence. Some mandated, others not, but a significant role, I would say, because, in many ways, these civil society groups represent a broad spectrum of the community that, in other ways, that wouldn't be represented at all.
To what extent, sir, did you attempt to take versions or hear the versions of persons who may have been implicated in one way or another in the commission of the violence?
Do you mean, did we hear from anybody that may have been implicated?
What I meant was, to what extent opportunity was given to those persons to give their side of the story?
Well, from the Commission's point of view, we were not reporting on anybody adversely, and some of the thinking around, obviously, as we've said in the report, not producing a list, if you like, of potential or perpetrators as we saw it, was that there was really very little opportunity to provide anyone that may have come into that category with an opportunity to defend themselves. So other reports, however, did point to people that they felt were implicated in the violence. And from memory, 2 people who felt that they should talk to us as a result of that approached the Commission, and we did listen to what they had to say.
Who were they?
Mr. Ruto and Mr. Bett.
for the record, would that be William Ruto and Franklin Bett?
Yes, that's correct.
I'd like to then move back to a document that I referred you briefly to before the lunch break. That's at tab 13, ERN 1288, 1288. And I believe you have already identified this as being the investigation and gender-based violence reports prepared by Bob Grinstead and Melinda Ricks, respectively, correct?
Yes, that's correct.
And can you identify this document as the reports or as a copy, reliable copy of the reports that you received?
Yes, that's...
Take
Yes.
the time that you need.
Yes, I believe so, yes.
Your Honours, I think I had not yet indicated the areas of the report in which the prosecution is interested. It is only the first report, that is the investigation report, which runs from page ERN 1288. Bear with me. Until ERN 1490. But in particular, the sections which we hope to rely on would be page 1295, ERN 1295, which is page 7 of the report, commencing at Commission of Inquiry into the Post-Election Violence General, until 1302. That's page 13 of the report, up until the heading Police Action. Perhaps we can do this as we go through it. You can confirm, can you, sir, that that portion, which is a bit smaller than what I referred you to earlier, is what you received from your investigator?
Yes. Yes, that's true.
And secondly, ERN 1397, at page 108 of the report, chapter headed Eldoret, until ERN 1423. Page 134 of the report. It's just before the page headed Nyanza province. Again, if you can just look through that and confirm if that's the relevant portion you received.
Yes, that's true.
Thank you, Your Honours. I will in due course be asking, I will ask the Chamber to admit this document as an exhibit, subject to written arguments in the manner proposed earlier.
Mrs. Steinberg, just a question or two for the witness at this point. Ms. McFadden, you said that there was, you said a part of the, should I say, procedure of the CPAV was not specifically to give opportunities to people who might have been accused, as it were, of the violence, individuals, if I understood you correctly. But then you say that, but other reports did point to people that the makers of those reports, I presume, felt were implicated in the violence. Was that what you said?
Yes, that's right. But also during the process of our hearing of witnesses, information came to us directly about that as well.
About those other reports that might have implicated people, do you recall what they were and whether you did take those reports into account in your final analysis?
Yes, well, one of the reports tendered as an exhibit by a witness before us did do that, and that was a report from the Kenyan National Commission of Human Rights, for example. Yeah.
Thank you.
Just to follow up on His Honour's questions, you say that you didn't specifically see it as part of your mandate to allow all peoples implicated to come and give their opinions. Was there anything preventing those people from approaching the Commission to have their say, as it were?
Well, no. I didn't mean to convey an absolute blanket barrier on people wanting to come and to see the Commission if they thought, well, whatever they thought, I don't know what was in their mind, but if they thought they might have been adversely mentioned somewhere or other, and clearly we would hear them if we could, and in fact, in a couple of occasions, we actually did so.
Thank you. Before I finish with this first folder, I have one further document I'm going to ask you to have a look at tab 11. That is ERN 00410679. The document is headed Reported Death Cases During Post-Election Violence Period. Do you have that?
Yes, I do.
Can you please tell the court whether you recognize this document, and if so, what was the genesis of this document?
Well, it's a... excuse me while I just turn around here. It's a tabulation of information around deaths during the post-election violence, as it says, and this one looks to be by province. Self-explanatory, really, the details, including the cause of death, the district, and from whence this information came, the source of it, if you like, with the exhibit number.
And the exhibit numbers, are they referring to CPEV exhibits?
Yes, a lot of this information would have come from hospitals and mortuaries and the like, so some of this information would have come from witnesses producing this in evidence.
All right. Is it the case then that this is a document that was compiled during the course of operation of the Commission.
Yes, that's right.
And as is clear from the document, it's compiled from a number of different sources. Is that correct?
Yes, that'd be right. There was no national source of information relating to Kenya as a whole for this sort of information. We had to collate it from different sources.
And can you comment, Ms. McFadyen, on the comprehensiveness of this report of deaths during the post-election violence period?
Well, I believe it's as comprehensive as a report that's ever been done on the deaths attributable to the post-election violence. I mean, there have been other numbers bandied about, but in the end, what we were looking to do was to produce a document that would come up with definitive information based on facts.
And if I can just draw your attention to the pages of most interest to the prosecution, starting at ERN 0690. Unfortunately, the pages are not numbered, apart from the ERN number. About 10 pages in. 7 pages in. The ERN number again, 0690. Do you have that?
Zero 0690, yes.
And do you confirm that halfway down the page, starting at item number 1 to item number 7, represents the deaths reported in the Nandi North district?
Yes, that's clear on this document, yes.
If I can ask you then to turn over 2 more pages and look at 0695, again starting at item number 1.
Yes.
This appears to be a list of deaths of people killed in the Uasin Gishu area.
Yes, that's right.
And if you can just page on to page 0707. Some 7 pages on. The final entry for the Uasin Gishu district seems to be 272, correct?
Yes, that's right.
And, well, it seems clear that this represents 272 reported deaths in that district.
Yes.
Thank you, Your Honours. This will be another item the prosecution will intend to tender as a witness. I understand that there are objections to this document. While learned friends will confirm that, then we can also deal with this subsequently by way of written argument.
Do you object to this particular document coming in as exhibit at this time, Mr. Ken, Mr. Kinkatwa?
Your Honor, on further reflection, we do not intend to oppose it. We do not oppose, Your Honor.
You do not object to this document being received as exhibit at this time. And Mr. Ken?
Likewise, Your Honor.
I'm grateful to my learned friends. I ask then that this be admitted as the next in the prosecution documents. Given that this does have names and medical details of the victims, I suggest that it be received as a confidential document.
So the document will be the entire document appearing at tab 11?
In fact, there are 2 documents at tab 11. There's a single-page document at the end I will deal with in due course. It's at ERN 0733. It's just a summary, yes.
All right, so we will then admit onto the record the first document, that's starting at 0679 to 0732. Is that it?
Correct, Your Honour.
That document is accepted as the next in the prosecution exhibits.
Le document
confidential document KenOTP 00410679 will have the number EVDT OTP 00129. Prosecution Exhibit 129.
Your Honours, I'm informed by my colleagues here that, in fact, this is one document. My last page was just not properly stapled. So may I take this opportunity to correct the ARN range to end at 0734 and not 0732. I apologize.
I take it defense, you have no objection to that correction?
None, Your Honour.
The amendment will be made accordingly, court officer. So 0733 and 0734 will form part of the last exhibit received.
Thank you, Your Honour. So perhaps I should also just ask the witness if you can please look at the last page in this tab, last two pages, the one headed Summary of Deaths per District. The other one hasn't got a heading. Do you have that?
Yes, I do.
This appears to be simply an addition of the global number of deaths that are set out in more detail earlier in the report, correct?
Yes, it does.
And turning over the page to 0734, we see the same order of areas with the total death numbers broken down by reported cause of death, correct?
Yes, that's right.
Thank you, sir. We can put that aside for the time being. Oops. Beg your pardon. Moving on then, did the Commission receive any evidence from government officials relating to internally displaced persons as a result of the post-election violence?
Yes, there was. Well, from my recollection, there was at least one government witness, a permanent secretary, I believe, who provided some information around internally displaced people.
And is it correct, sir, that this would be Mr. Francis KenyaMOJA, permanent secretary at that time?
Yes, I believe it's Francis KenyaMOJA.
And did Mr. KenyaMOJA produce any statistics relating to the numbers of internally displaced persons as a result of the violence?
Yes, he did.
And I'd ask you please to turn to the second bundle, second folder, the first tab, tab number 14.
While he's getting the tab, Mr. Steinbach, you might want to help the transcript with the spelling of Mr. KenyaMOJA.
Sorry, Your Honours, I wasn't following the transcript. It's K-I-M-E-M-I-A, KenyaMOJA. Francis would be the normal spelling.
Monsieur Steinberg, pourrions-nous avoir un numéro ERN?
Do we have a number for that, Mr. Steinberg?
Certainly, it's ERN 00059365. Thank you. You recognise that document, sir?
I'm just looking.
Oh, sorry, it's at tab number 14. It's the
yes.
first document in the bundle, headed Annex 1, Status Report on IDPs.
Yes, this is this is a status report on IDPs.
Do you recognise this, sir, as a report that was handed in by the Permanent Secretary?
Well, it appears to be, although without, I mean, it was 6 years ago, so without linking it back to the exhibit and the witness number, I'd have a little. But Mr. KenyaMOJA was responsible for this area and did provide us with information around IDPs.
If you turn to the last page of this document, second last page, I beg your pardon, there appears to be a total of figures, and under two headings: one, total number of IDPs returned home, and IDPs currently in camps or integrated. The figures are given as 210,594 and 21,431, giving a combined total of approximately 230,000, correct?
Yes, that's right.
According to your understanding, did this amount to the sum of internally displaced persons in the country as a result of the PEV?
No, this figure, in my view, would be underreported. Not deliberately so, it's just it is what it says it is. The total number of IDPs returned home, 210,000, which is fine. Still 20,000 in camps, although I know a lot of people argued that it was more than that. What it doesn't show are IDPs who didn't go to camps in the first place. Many IDPs were, people were displaced from their homes but didn't seek refuge permanently or semi-permanently in camps. What they did was they went either to home areas or districts or other districts out of the area that they were fleeing from, and made their own arrangements, I guess you could say, for their safety.
And during the course of the Commission's work, did you arrive at what you believe to be a total figure of IDPs generated as a result of this violence?
Well, yes, the figure that we concluded was 350,000 from memory.
And turning to page 3 of this document at 9367, there's a heading Uasin Gishu. Do you have that?
Yes, I do.
And in particular, it's noted here that at the Eldoret Showground, a total of 14,664 IDPs had been returned home from that area, but 6,687 remained at the time of this report.
Yes, that's what that says. Yes, correct.
And your comments about underreporting, I presume, will likewise apply to this area.
Yes, they applied across the board. That was our understanding from information that we'd received during the course of the commission.
Mr. Steinberg, you will of course be asking about how the higher figure was arrived at, will you not?
Your Honour, I think that would be best done by referring the witness to the relevant chapter of the report, so perhaps I can proceed to that in a moment, but I should first indicate that the prosecution will again seek to tender this document, underreported as it may be. I understand there are objections. If I can just confirm that, we can then deal with this later too.
Well, Your Honour, there are objections, and indeed I've got concerns about a lot of what's being done, because there's been no evidence, no foundation laid with the witness as to, apart from receipt of the document, any inquiry or investigation done to look into either the accuracy of this document that the prosecution wishes to tender, or any process that gives rise to a higher estimate. And, Your Honour, it's not good enough either for my learned friend to say he's going to take the witness to the part of the report. I think questions should be asked in a very direct manner. Upon what basis do you say there's a higher estimate? But, Your Honour, if the prosecution say this is unreliable, that's a further factor militating against admission. Now, Your Honour, we can argue this later, but one wonders the utility of spending court time on a document like this that the prosecution itself says is not reliable.
Your Honour, we had indicated that we are objecting to the production of this document.
Let me see if I can address my learned friend's concerns, Your Honour. You've indicated, firstly, well, perhaps I can simply say that as regards the reliability or otherwise of the document, the prosecution intends to rely on it to support this as a minimum figure of IDPs. I will direct questions to the witness as regards his reasons why the Commission concluded that it was underreported. You indicated that the Permanent Secretary responsible for IDPs testified at the Commission. Is that correct?
Yes, I'm not sure of Mr. Kamimi's full title, but it covered a range of things, including security, I believe.
And and he gave evidence, I presume, in regard to the numbers of witnesses. Sorry, I'm being distracted. The numbers of IDPs that his department was responsible for.
Yes, he gave evidence before the Commission across a range of things, including this piece.
Your Honour, I raise another objection. There are provisions of Rule 68. The prosecution now is going to the substance of testimony in a different proceeding that had a different limited mandate and which is completely different from the task which Your Honours are engaged with. The due process rights, the remit, the depth of investigations cannot be compared by any stretch of the imagination. But Your Honours, Rule 68 provides certain safeguards to the defence in relation to putting forward evidence that has not been tested by the defence. Now, all these individuals, and there's many examples that will be dealt with in the written objections, the prosecution could have called them. What they cannot do, what we say is completely impermissible, is to ask Your Honours, and of course Your Honours won't do it, but we're sure, to abdicate your fact-finding responsibilities by receiving evidence that the defence has been denied an opportunity to confront. That's in breach of the statute, Rule 68, and our right under international human rights law to confront the evidence. And Your Honour, I say leading it in the manner that my friend is attempting to do is also an attempt to circumvent the due process rights that we are entitled to under the statute.
I take your objection to mean that the chambers should not base itself or finding on the basis of hearsay evidence of attributed to Mr. Kememe. Is that it?
Your Honour, not just hearsay evidence, any evidence. Repeatedly, the prosecution has objected when I've attempted, and my team has attempted at various times, to refer to statements of people outside the courtroom. And they've objected, and those objections have largely been upheld.
So let me be clear here. It's one thing to have a witness who has come to testify as to what was done in the PEV, in the CPAV process, to listen to the witness, to understand what happened, how they did the work that resulted in a report that may and may not be received. It's quite another matter to say, well, on the basis of this testimony, the chamber should make a finding at the end of the day. Isn't that where the thing boils down to?
Your Honour, in our respectful submission, what my learned friend is attempting to do is to make the respected witness a surrogate voice for Mr. Kememe. It's through the vehicle of the witness that Mr. Kememe's purported testimony is put before the bench as part of a record. And then what is the defence position? It is there in the record. It's not there for artwork. It has to be confronted and dealt with. We say it's impermissible. The proper course, and of course all questioning, must be limited, constrained by relevance and probative value, as against prejudicial effect. The correct course of action would be to call witnesses, hear what they say, and we challenge them in a direct manner, not in the manner that my learned friend is attempting to do through the witness that's before you.
Mr. King-Kaswa?
We take the same position, Your Honour.
Mr. Steinberg?
Your Honour, the prosecution has not sought to introduce the testimony of this particular witness. Other witnesses we will get to in due course, but not this particular witness. The questions I put to this to Ms. McFadyen in this regard are as a direct result of my learned friend's previous objection, which is to say that the prosecution had not established the reliability of the document, the statistics, which I had sought to tender. And it's for that purpose that I'm asking the witnesses, or I intend to ask the witness questions about to what extent the evidence of that witness was tested to understand the reliability of the statistics and hence the probative value of this document. So that's where I'm going with these questions. But my learned friend raises a broader issue which will become relevant to further documents I intend to ask this witness to identify. And he refers to the right of the defence to challenge evidence, and that's undoubtedly a right which is granted to the defence team as part of the right to a fair trial. But in my submission, this right must be balanced against the right of the chamber, as provided by the statute and rules, to freely assess relevant evidence. And there's obviously a balancing which must be done. One knows that in international tribunals in general, and this tribunal in particular, rules of admission of evidence are more relaxed than in certain national jurisdictions, in particular in regard to the admission of hearsay evidence. But, Your Honours, I would submit that this is par excellence the type of argument which should be dealt with in the written argument in the manner which I proposed and was agreed earlier. So I will lead the witness only to the extent that is necessary to demonstrate or to support the probative value of the evidence I intend to submit, which will be a factor relevant to the admission or non-admission of this evidence in due course.
And the Chamber's ruling is that you may proceed. Mr. Khan, your concern is noted. Confident that you can deal with that at the point.
I'm grateful.
Thank you, Your Honour. If I could just see where I was. Thank you. Mr. McFadden, yes, I was asking you then about the extent to which the evidence of Mr. KenyaMOJA would have been tested during the course of his evidence.
Well, his evidence would have been tested in the way that any other witness appearing before the Commission would have been tested. So, once again, the usual arrangements apply, sworn an oath of telling the truth, and also answering questions from counsel with standing and others.
And the issue of the underreporting and ultimate figure of 350,000 IDPs, how was that figure arrived at?
Well, I believe that that was arrived at through a number of ways, including hearing from others, other than Mr. KenyaMOJA. I don't recall whether, in fact, that particular issue was put to Mr. KenyaMOJA during his evidence or not. It may have been, and he may have responded that way, but I don't recall whether he did or not. But I know, if I can say this, that at least one or two other senior people had come up with the figure of 350,000. So there we go.
Perhaps if I can then at this stage refer you to your report, Chapter 7, it's the CPEV Final Report tab 12 of the first bundle, page 272. For the record, it's ERN 00010646.
What page again did you say?
It's report page 272, ERN 0646. Do you have that, sir?
Yes, I do.
Firstly, in general, this chapter contains, it seems, your findings on internally displaced persons, correct?
Yes, that's right.
And in the middle of the page 272, the first paragraph after letter D, the last sentence of that paragraph contains a statement. According to the government, there were 350,000 persons displaced as a result of the PEV after the 2007 elections. And
sorry.
In the footnote, you refer to Mr. Francis KenyaMOJA as the source of that evidence.
Yes, that's right.
Thank you. While we have the report open in front of us, can I also ask you then to turn to Chapter 9 at page 304, ERN 0678. 8.
Yes, I have that.
And is it correct that in this chapter you contain, or the report sets out its findings as a result of the extent and consequences of the violence, including the number of persons killed and injured?
Yes, that's right.
Please. Thank you. Could you please put that report aside for one moment? I'd like to move to the next exhibit to show you. All right, you can skip over the exhibit at tab 15 on reflection. I don't think that's necessary. And go to tab 16, ERN 00090380. Do you recognize this document, sir?
Yes, well, I seem to recall that this was a document or an exhibit, actually, produced by a commission witness. Well, obviously number 131.
Are you referring to the number in the top right-hand corner, 131C?
Yes.
And what does it represent?
Well, it on the face of it, represents some commentary by a group, or purporting to be a group.
Is this public document?
There's no identifying information in this document. I see no reason why it cannot be public. Yes, continue.
Well, it indicates that on the basis of whoever would be distributing this, that they wanted certain things to happen. I mean, did you want me to read it? It's
No, I think it speaks for itself. Thank you.
Mr. President, Your Honour, just briefly on that matter. I just note, and it's maybe it's an omission, but despite proofing, there is no record before the oral testimony now that the witness had recognised this particular document. And, Your Honour, the reason I've got additional concerns is the prosecution has also provided an index of all the exhibits that were presented to WACI, and Your Honour sees at the top corner 131C. That is not part of the list of exhibits in that other document that the prosecution have presented to the court. So, Your Honours, I raise that. It's not in the proofing note, and the number itself doesn't even correspond with the WACI exhibits. And that's why I'm a little bit surprised now that the witness has said, after proofing, that he recognises the document. So I just record that. If a supplementary proofing note can be prepared, I don't know if it's necessary, but I've got some concerns about that.
Are you saying this is the first time you've seen this document?
Your Honour, we've seen the document before, but there was no indication that the witness had recognised it. not in the statement, and not in the proofing when he was shown the document. There's no indication that he said, I recognise that document. And looking at the list of exhibits that were presented to WACI, this document does not appear, at least to us, to be on that. My learned friend corrects me, well and good, but one sees on the top of this prosecution exhibit 131C that appears to have some similarity with the sequence of exhibits in WACI, but yet there's no reference in the WACI exhibit list that my friend has provided to the bench of a 131C or a document like this. So that's why one is a little bit taken aback about the provenance. Your Honours, of course we have no information where this came from, which witness tendered it, what is this capillary network, provenance, all these issues, and yet it's come from somewhere and the prosecution are putting it to a witness. We say it puts the defence at a significant disadvantage, because what on earth can we ask?
Let me ask one thing you can ask. Witness, do you recall seeing this document during the process, the CPAF process?
Well, I couldn't say that I could exactly recognise this document. I remember something similar, but that's all I can say.
You mean something to the same effect?
Yes, something that words to this effect, but I couldn't say specifically. It was a little time ago, Your Honour.
Mr. Steinberg?
Your Honour, I ask that we come back to this. My learned friends, my colleagues are just checking whether this document is referred to in a separate list, apart from the list that this witness identified of witnesses and exhibits. But I have to check and come back on that.
You may proceed with your examination, even on this document.
Even on this document,
thank
you.
Questions on that. Mr. Can is basically putting you on notice as to his difficulties with it, and he will make his argument at the appropriate time.
Thank you, Your Honours.
Could I just ask that my learned friend, we've only got one list of exhibits that were presented to WACI. Whilst he carries on with his questioning, could we have the ERN of the second list that he apparently has that contains references to the WACI exhibits? We only have one list, and that's the one that's been provided by the prosecution today. So just the ERN would be very helpful.
That's exactly what my colleague will be checking into, and we'll come back on that. This document perhaps then brings me to another topic relating to the Commission's findings on the nature of the post-election violence, and in particular, what evidence did you consider as regards the issue of spontaneity or otherwise of the violence that was reported or that was testified on?
Well, I object. This is an ultimate issue. What on earth, what utility can be had by another witness giving an opinion on one of the key issues in this case, whether or not violence was spontaneous or planned? One doesn't call even a judge of a lower court to appear as a witness and give certain views as to credibility. In a higher court, you look at the judgment, and you are confined to the judgment. What the prosecution are doing is improper, we say, improper. These kind of questions on spontaneity and planning are matters that are reserved for your bench. They must be decided by proper evidence, properly led, viva voce evidence or expert evidence, and you have the prosecution are trying to put in a report. But to get the witness, one of the three commissioners, to give views on that is, we say, improper. It's seeking to arrogate one of the key responsibilities that the Assembly of State Parties have entrusted to your honours, not, with all due respect, to the witness.
Mr. King-Kaswa?
We take the same position, Your Honor.
Mr. Steinberg, any reply? No response, rather.
Your Honour, the ultimate purpose, as Your Honours have noted and my learned friend has noted, in this is to obtain evidence which will support or otherwise the admission of the CPAV report. As part of this process, I seek to examine with this witness underlying material which was relied upon to come to the conclusions that are set out in the report. One of the factors to be taken into account in deciding upon the admissibility of this report or any document is the probative value of the information contained therein. Your Honours are well aware that it will involve a process of weighing that probative value against any prejudice which my learned friends may assert would be occasioned by the admission. And for this reason, I wish to traverse with this witness the basis upon which the Commission came to their conclusions regarding spontaneity or otherwise. And I understand there was a wealth of evidence on this point from contradictory points of view. So it may, and indeed much of this evidence will assist my learned friends.
Your point is that the Commission, in their reporting, did come to conclusions about spontaneity or lack of it, of the violence. Is that it?
There were certain...
And you want to explore with the witness the basis of any such conclusion?
Indeed, Your Honours.
Your Honours, two observations, if I may. My learned friend has previously said that there is no intent to rely upon anything from the WACI report in relation to acts and conduct of the accused. Your Honours, whether or not violence is planned or spontaneous is one of the key features, one of the key pillars of the prosecution's case. We say the questioning trespasses onto conduct, and if it's not, it's on a line without a distinction. Your Honour, the other matter is, with the greatest respect to the...
But if what concern is it to you if the Commission had come to the conclusion that violence was planned, but it may not have been your client that planned it? Why can't he talk about that?
Your Honour, the reason is this, that with the greatest respect to the WACI Commission and their difficult job in the 2 months or so that they conducted investigations, whether they make findings that violence was planned or spontaneous or unplanned, whether X or Y or Z was responsible or no finding of that, it's irrelevant, absolutely irrelevant, because Your Honours will be anxious never to abdicate your own fact-finding responsibilities. So what relevance is it that another court formed certain conclusions that are material facts and issues in the present proceedings? It imperils the defence. The proper way for the prosecution, of course, we had no say in their witness list or their witness order. They had an obligation to bring evidence, witnesses that could be tested in relation to all of the aspects of the case. And, Your Honours, the fact that they, with respect, we say have outsourced and they have abdicated their investigatory functions to simply accepting the wacky boxes and say we have a case, let's go forward to trial, is not enough to say that Your Honours should be asked to do the same thing. Your Honours, the prosecution effectively are inviting Your Honours now to do exactly what they have done, which we say is wrong.
But it doesn't follow. Yes, we do have our own minds to make up at the end of the day. So without abdicating the obligation we have to make our own findings, there's nothing wrong with this. I see no inconsistency with knowing how others came to their own conclusions as well.
Your Honour, the reason is this, that are we here confronting evidence relating to the charges and the witnesses, the prosecution are brought forward within certain clear parameters? Or are we going to inquire as to the merits or otherwise of the WACI Commission? Because if it is relevant for the prosecution to start asking about the findings of WACI, how long will we have to start trawling through the witnesses and the basis of those findings? Your Honour, it's a recipe for massive delay when Your Honours can hear evidence out of the horse's mouth by way of witnesses who give their own different part of the panorama of the prosecution's case.
Mr. Khan, we're again confident that you can deal with that
So be it. I'm grateful.
point. So the objection is overruled. You may ask the question, Mr. Steinberg, except that you have to start tomorrow at 9 o'clock. Go to that.
I'm grateful, Your Honours.
9:30. 9:30.
I'm even more grateful for that, Your Honours.
So we will adjourn now for the day. Witness, thank you very much. We will be taking our break now. Please join us again tomorrow at 9:30.
Mr. President, did Your Honours have an opportunity to consider the joint application, whether or not we would be allowed to start our cross-examination on Monday?
Not yet, Mr. Khan, but at the pace that we're going, it may be a redundant matter to deal with.
So be it, I'm grateful.
We will adjourn now and reconvene tomorrow at 9:30.
All rise. We will wait.